principle of
before we
necessity.
examine international humanitarian law, let's
Yes,
talk
Your
about whether the attack is justifiable under the prohibition against use of force. So what are the requirements that must be satisfied in order for anticipatory self-defense to be considered as legitimate under international law?
The attack must be proportionate, Your Excellency, under international humanitarian law also.
That would be one of the requirements, proportionality.
Yes, and also necessity.
Imminence and necessity?
Yes, it is also one of the requirements, Your Excellency.
Okay, how about imminent? Can you address that point, whether it is imminent or not?
It is an imminent threat, Your Excellency, because the weapon of mass destruction creation is for is going to be used eventually, and it is and the readiness of weapons of mass destruction is already a clear threat to regional security, Your Excellency.
What is your authority for that assertion?
It is located in the UNSC 4795K. It is stated that it must also that in that case the South Africa was called on to stop its weapon of mass to stop its nuclear weapon creation because of the possibility of the nuclear war could be happen regarding because of the creation of the nuclear weapon from the South Africa, Your Excellency.
Right, the creation of nuclear weapon by South Africa.
Yes, Your Excellency.
So there was the Security Council resolution. It was adopted because of the attempt made by South Africa to produce nuclear weapon. Is it?
Yes, Your Excellency.
All right, we'll proceed.
Thank you so much, Your Excellency.
Council, I'd like to interrupt you. Council, I want to interrupt you. I'm not persuaded by your argument that this threat from Roxana was imminent. First of all, you said that it's a weapon and therefore it must eventually be used. First of all, I don't agree with that. It means not all weapons are always used. That's clearly true from just looking around our world. I mean, there hasn't been a nuclear attack in many, many years, but there are many nuclear weapons. The second point is that, I mean, unless there's something in the facts that shows that Roxana was threatening to use it against Azura, I mean, then at least I might be partially convinced, but I didn't see any of that kind of a threat to use the weapon as well. So I don't see how it was an imminent threat. It looks like they were just developing some weapons, nuclear weapons in this case, as many countries do around the world, but not everybody's attacking everybody. Can you address my concerns?
Okay, Your Excellency. We do understand your concerns regarding the possession of the nuclear missile by the respondent state. But actually, Your Excellency, there has been so many cases that have talked about the disarming of nuclear weapons, Your Excellency. For example, from the North Korea, on its resolution, it is stated that the creation and the possessing of its nuclear weapons is a violation because it is concluded in a bad faith and it is a line to it is hard to come to a sense that nuclear disarmament, Your Excellency, and the use of the nuclear weapon by Roxana happened in the current case when they tried to test the nuclear weapon and similarity of the UNSC of the resolution on the Korea. The UNSC has considered that the test of the nuclear missile from North Korea is a threat to international law, Your Excellency.
Yes, Council, you can proceed with your submission.
Thank you so much, Your Excellency. The attacks also were in line with the principle of necessity, Your Excellency. The military necessity denotes nothing more than a given course of action required for the accomplishment of a particular military goal. In the oil platform case, the United States armed action in self-defense was not a necessity, since the location of the oil platform was accused of creating a WMD, weapons of mass destruction, is not true at all, and it is not a threat towards the USA nor the regional security, Your Excellency. Hereby, the attack was not in accordance with the principle. However, Azura's attack were in line since the objective of the attack was to a nuclear disarmament, Your Excellencies, and the attack was clearly from weapons of weapons of mass destruction, and thus the military goal was achieved, Your Excellency.
In this situation, if I may ask, if you look at the object of the attack, Azura attacked various military installations, those facilities which were not related to the storage of nuclear weapon, isn't it? Is it necessary for you to attack all military facilities in order to stop the production of the nuclear weapon?
Yes, Your Excellency. It is the objective of the attacks from the Azura state is in line with the principle of proportionality, Your Excellency, because the aim of the attack from the applicant state was an attack to reduce the support of the usage of the usage of the usage of the hypersonic nuclear missile by the respondent state, Your Excellency.
I see. All right. Okay. So I do have one more question about the application of the principle of deterrence on the part of Rosanna. So there is no prohibition under customary international law for a state to possess nuclear weapon, isn't it? And in this situation, Rosanna possessed the nuclear weapon for the purpose of deterrence, not to attack other countries.
Yes, we do understand your concern, Your Excellency. But however, a possession of a weapon of mass destruction is already a violation, because state cannot wait for the usage of the nuclear weapons itself. Then to take action towards it, we have to take action before there was a usage from that nuclear weapon, Your Excellency.
Council, I'd like to jump in again. You say that the state must take action and not have to wait for the missile to be shot. I understand that point, but would you not agree, though, that before Azura takes action, shouldn't they have to exhaust all diplomatic efforts? And in this case, from what I can tell, they just sent out some press releases. It doesn't seem like they made any serious efforts to resolve this diplomatically. Can you address this?
Yes, Your Excellency, we can. If I may direct you to paragraph, paragraph 13 of the Moot problem, it is stated that Azura and other international community has already create a platform for so that they could talk about this, Your Excellency. It is already happened in the Moot problem, Your Excellency.
All right, proceed.
Thank you so much, Your Excellency. Entering our second sub-argument, Roxana possession of the hypersonic nuclear missile is not in line with international law, Your Excellency. The state obligations on nuclear disarmament is located in the Non-Proliferation Treaty, Article 6. These state obligations are applicable since the obligation was a result from a widespread practice. a majority
Council,
of
but
states.
I think from the statement of facts, Rosanna has not ratified the NPT, isn't it?
Yes, Your Excellency.
So why are you invoking the NPT?
It is because the non-proliferation treaty is already considered as a customary international law. As you could as we could know that in the paramilitary action in and against Nicaragua in 1986, it is stated that customary international law have two thresholds, Your Excellency. First, it has to be there's a state practice to it, and second, that it is an opinio juris, Your Excellency.
All right. Okay. So in what way the NPT has satisfied these two requirements in order to say that it has become customary international law?
Yes, Your Excellency. So the NPT has lots of state practices already. For example, many states, irrespective of their subscription to the NPT, Your Excellency, they are taking active steps to reduce number of nuclear weapons. For example, in South
How many
Africa,
states have ratified the NPT?
they have not yet at the moment, Your Excellency. But
Yes,
however, they are
not ratified yet. But I'm asking you, how many states have ratified the NPT?
NPT parties are NPT's parties are around
Council, I think you can proceed with your argument. Maybe you can deal with this point later on in your rebuttal because you have 1 minute left. Proceed.
I see that my time is almost elapsed, Your Excellencies, Mr. President. May I have additional minutes to conclude my arguments?
How many arguments you have left?
I still have around 3 arguments, Your Excellency.
Okay, I think you can summarize your arguments. We give you another 5 minutes for you to do that. Is it okay, my learned colleague? All right, okay, proceed.
Okay, thank you so much, Your Excellencies. Again, this state obligation was a result from a widespread practice. For example, on South Africa, before signing to the NPT, they already entered a nuclear weapon. They already ended their nuclear weapon programs to negotiate its way to nuclear disarmament. And the same occurrence also happened to Ukraine when once they possess the world third largest nuclear weapons, and they ended up entering a bilateral treaty that achieved the same objective, Your Excellency. And regarding the NPT being an opinio juris, it is stated that from past resolutions for calling on all states, UNGA obligated to negotiate nuclear disarmament in good faith, regardless their membership to the NPT. And it is also stated also in that in the Tadic case, also mentioned that UNSC resolution are of a great relevance when evaluating the formatting of opinio juris. The Council has also affirmed the need of all states to conduct negotiation in good faith. Even though these resolutions were not binding, this court has recognized normative value in certain circumstances. Thus, this contribution to opinio juris supported the state practice stated before, and it shows that the existence of customary international law in the correlation to Article 6 of the NPT, Your Excellency. And
Council, I have one quick question on your argument that you just made.
Yes,
Are you arguing that the ICJ, us, or some other international authority has already declared that the NPT is customary international law, or are you suggesting that that has not happened yet, but you want us to find that the NPT should be considered customary international law?
It is a customary international law, Your Excellency. From the examples that I have given you before, it is qualified to be a customary international law. Entering our second major argument, that Azura does not have to compensate for two reasons, Your Excellency. First, Azura did not do an internationally wrongful act. Azura's only goals from launching their military forces towards Roxana is based on good faith for disarming nuclear weapons that are in the possession of Roxana, and because it is a threat to national and regional security. In Article 36 of RCWA, it is stated that a state responsible for internationally wrongful act and is under an obligation to compensate for the damage caused. And in the Corfu Channel case, obligation to compensate arose from breach of international obligation by states. However, in the present case, it is submitted that Azura did not conduct any wrongful acts, internationally wrongful acts, and their attacks are in line with international law, Your Excellency. And lastly, on our last sub-argument, Your Excellency, if the court in any way found that there is an internationally wrongful act, the attacks are still justified for its exercise to self-defense under RCWA. In Article 21 of RCWA, it stated that the wrongfulness of an act of a state is precluded if the act constitutes a lawful measure of self-defense taken in conformity with the Charter of the United Nations. Here, Azura's fulfilled its obligation and obligation in good faith for nuclear disarmament, Your Excellency, and there is no an international obligation breached by the applicant state. If this court has no more inquiries, may it please the court.
Right. Okay.
Thank you so much, Your Excellency.
If there are no more inquiries from my learned colleague, I would like to proceed. We can proceed with the next counsel for the applicant.
There's no inquiries.
Counsel, I have one query.
Oh, yeah.
In your last statement, you were saying that Azura can justify under UN Charter, right? So most probably you are referring to, could you please enlighten us which article you are referring to, and did you fulfill the requirements under that article for you to say that Azura's preemptive attack is justifiable under UN Charter specifically? Sorry, you are muted, Counsel.
Yeah,
My apologies, Your Excellency. As I stated before, in Article 21 of RCWA, it stated that the wrongfulness of an act is precluded if the act constitutes a lawful measure of self-defense taken in conformity with the Charter of the United Nations. And as you could see that in the Article 51 of the United Nations Charter, it is also stated that that a state could have that the state could exercise its inherent right of self-defense, Your Excellency, if there's any clear threat to its national security, Your Excellency. And hereby, because of the act conducted by the applicant state under self-defense is justified under international law. Hereby, that Azura does not have to pay for compensation, and there is no breach of obligation under international law, Your Excellency. Thank you so much, Your Excellency. Mr. President, may it please the court.
All right. Okay. Yeah, we can proceed with the next submission.
Am I audible, Your Excellency?
Yes, you are audible.
Good afternoon, Madam President, Your Excellency. May it please the court. My name is Nazal Firdaus, and I'm the co-agent appearing on behalf of Republic of Azura as the applicant in the current proceeding. As introduced by my first agents, I will be dealing with the last submissions in the next 16 minutes. I have the honor to address applicants' final submissions concerning United Provinces of Roxana violates international law targeting Octagon with its hypersonic missiles and must pay reparations for Republic Azura for the damage suffered. If this court has the preliminary
Can you
inquiries,
repeat that again? Sorry, it's not clear. It was not clear. Can you repeat that again?
So our concerns under this proceeding is that United Provinces of Roxana violated international law in targeting Octagon with its hypersonic missile and must pay reparations to Republic of Azura for the damage suffered.
Proceed.
If this court has no preliminary inquiries, we would like to continue with applicant submissions.
Proceed.
Madam President, Your Excellency, may please the court. On 29 October 2022, the United Provinces of Roxana found that the constant dispute with the Republic of Azura would put them on the brink of the collapse. Thus, they deployed.
Sorry, can you speak slower, please? Slowly.
Yes, sir.
Right. Proceed.
On 29 October 2022, the United Provinces of Roxana found that the constant dispute with the Republic of Azura would put them on the brink of the collapse. Thus, they deployed their nuclear missile with the concern to rife the grave consequences to the Republic of Azura. This attack caused the severe causalities, destroy the critical facilities, threat, and give constant trauma to the civilians. As a result of the attack, applicant raised two claims against Roxana, namely, first, the United Provinces of Roxana violated international law interrogating Octagon with its personnel missile. Second, Roxana entitled by reparations measure for the injury occurred. Your Excellency, moving to the first claim, we submit that the United Provinces of Roxana violated international law interrogating Octagon with its supersonic nuclear missile. There are three sub-argumentations in supporting our first claim. Those are, first, respondent violated the charter. Second, respondent violated the international humanitarian law by using its supersonic nuclear missiles interrogating Octagon. And the last, Roxana violated the human rights law. Moving to the first reason, or first sub-argumentation, respondent violated the charter. There are several reasons in supporting these sub-argumentations. First, it's violate the principle of non-use of force under the charter. It's stipulated under Article 2, Paragraph 4 of the charter that state must refrain themselves to using force against other state territorial integrity. To determine the justifications of the use of force, we would like to bring the Nicaragua case. The judge exercised that the use of force as a part of self-defense must be first proportional necessary. Referring to this proceeding, Roxana has no proportionality in using its force for attacking Azura, proven by the causality left by the attack was severely excessive. In addition, the attack is not necessary because the launch of a nuclear weapon conducted by Roxana is not the only way.
Why do you say that the attack was not proportionate? Why do you say that it was excessive?
Because we say that it is excessive because the causality is very severe and it is bring a suffer to the civilians mostly, and they didn't get any significant military advantage by attacking Octagon itself in comparisons to the causalities to the civilian itself. Moreover, we say that it is not proportional because they are fail to exactly targeting its hypersonic nuclear missiles to the military objective, Your Excellency. So it is.
Council,
Yeah.
Council,
So
if I can interrupt you there, when you were talking about the first part of proportionality, you said that Roxana did not get any or adequate military advantage from firing this missile at the Octagon. I'm not persuaded by that. I mean, this is the headquarters, right? This is the brains of the entire military operations of Azura. Why would it attacking and blowing up the Octagon not have a great military advantage? I'm not persuaded by your point. Can you persuade me?
Your Excellency, I'm more than happy to answer this because we believe that military advantage defined that it's first ground gaining measure, and second, it is the process of weakening enemy's troops. We submit that it cannot give them, and it is not weakening the enemy's troops, but they are give a more than that effect. They are killing and giving massive destructions for that. So we think that it is not a military advantage that is regulated under the international humanitarian law. So it is not justifiable, Your Excellency.
All right, you can proceed.
Thank you, Your Excellency. Moving to the second sub-argumentations. Second reasoning. Roxana's actions cannot be justified as a self-defense. Your Excellency, the use of force is a part of sort in self-defense, which is acknowledged under the Charter Article 51. However, this is subject to the principle of proportionality and necessity. And in the present case, Roxana's attack does not fulfill those principles. That is because Roxana unable in targeting Octagon concrete and direct for resulting in military advantage, right? Also, it is not necessary because Roxana's attack was not going, and there is no another realistic measures in achieving the cassations of attack. In sum up,
sorry to interrupt. Your microphone it went mute for a couple times. Can you repeat the last couple sentences?
That is because Roxana is unable to targeting its attack concrete and direct for resolving military advantage. Thus, we say that it is cannot be justifiable as actions in accordance to the proportionality, Your Excellency. Moving to the second sub-argumentations, the respondent violated the international humanitarian law by using its hypersonic missiles in targeting of. There are two.
Counsel?
Yes, Your Excellency.
But at the same time, you look at the statement of facts. Rosanna attacked. The applicant attacked Rosanna, isn't it? In which it caused massive destruction to their infrastructure, and the fact that despite the fact that they keep on saying that the nuclear weapon was only for deterrence purposes, actually, I think from the statement of facts, your client had provoked, the applicant had provoked the nuclear attack, isn't it? Despite the fact knowing that they have nuclear weapon, you still proceed with the attack. If you look at the current scenario, the only reason why states have not attacked Soviet Union because Soviet Union possessed nuclear weapon. Nobody would dare to attack nuclear weapon. But in this situation, the applicant dare to attack a country which possess nuclear weapon. So this outcome is predictable, isn't it?
Yes, Your Excellency, it is predictable. But based on what my previous counsel already said, that on our side, we submit that the earlier strike must be conducted before the launch of this hypersonic nuclear missiles in assure that we can gain the military advantage earlier rather than the other party, which is the respondents. Because the imminent
threat, any weapon left.
It's very clear.
They don't have any weapon left because you have already destroyed their military facilities. And I think the only way that they can counter the attack launched by the applicant is by using the nuclear weapon.
Your Excellency is not still justifiable in our side because based on the proportionality principle, it must be equal in responding the earlier strike with the same effect of this. We think that it is in the previous explanations, we already explained that they are these weapons is something that cannot be controlled and they cannot be redirected to the military advantage. Moreover, they are already aware that the severe casualties would breach several international humanitarian law and customary international humanitarian law, Your Excellency.
But the same thing can be said about your client, isn't it? About the applicant. Okay, knowing the fact that they have nuclear weapon, you still attack them. Proceed.
Okay. Thank you, Your Excellency. Proceed to the our submissions. Roxana violated the international humanitarian law by using its hypersonic nuclear missile in targeting Octagon. There are three sub-argumentations. First, Octagon is not a military objective. Second, the hypersonic nuclear missiles is an indiscriminate weapon which leads to this indiscriminate attack. And the third, the respondent violates its responsibility to maintain peace and order. Let's moving to the first analysis. Octagon is not a military object. Under IHL, an object must fulfill two elements to be determined as a military objective, which must effectively contribute and second, give military advantage. It is stipulated
under IHL. What is the nature of the armed conflict?
Yes, Your Excellency.
Yeah, what is the nature of the armed conflict?
the nature of the armed conflict.
Yes. Is it international armed conflict?
Yes, we believe
Alright.
that it is international armed conflict.
So which rules we should apply here in order to determine whether an object is a military object?
It is stipulated under international humanitarian law, Rule 8.
Rule 8 of the customary rule.
Yes, Your
But I
Excellency.
believe both states have ratified the Geneva Convention, isn't it, and the additional protocols. Which provision of the additional protocol we should apply here?
It is on the additional protocol 1 because the prerequisite of additional protocol 1 must be under the international armed conflict, Your Excellency.
All right, okay, proceed.
Thank you, Your Excellency. In the present case, the tech targeting the octagon does not give a military advantage, where the military advantage should be concrete and definite on the military objective itself. However, in the present case, the tech is not proportionate and necessary since the causality of the tech are not concretely addressed to the octagon. In addition, in the NATO bombing case, is considered that the need to avoid targeting the military advantage if there is likelihood of collateral damage or causing long-term damage. So,
Counsel, you mentioned about the NATO bombing case.
yes.
Okay, what is the citation of that case? Is it decided by International Court of Justice?
No, Your Excellency. It is under the final report of the prosecutor in the ICTY court.
All right, okay, proceed.
Thank you so much, Your Excellency. Second reason why it is unjustifiable under international humanitarian law, because the attack using hypersonic missile is indiscriminate attack, which can be resulted to unnecessary suffering. Under customary international humanitarian law, the usage of weapons that are naturally indiscriminate is prohibited. Undiscriminate weapon could refer to those weapons which cannot be redirected at military objectives or whose effect cannot be limited as required by international humanitarian law. Furthermore,
at the same time, even though you said that it is indiscriminate weapon, isn't it?
Yes, sir.
Probably because of the radius of the attack is quite large, but they have given warning to Azura the fact that they are going to use nuclear weapon, isn't it? You have ample time to evacuate everybody to minimize the casualties. So there is a liability on the part of Azura at the same time?
Your Excellency, yes, that's true that it is stipulated under no problems that the respondent already notified us. But as I said before, that the locations of this octagon itself is directly in a capital city of our country. So it is
yeah, that's the problem right now. Why the octagon is situated in the capital city of your country? So if this is a legitimate military target octagon, then it should be located somewhere far away from the capital city, isn't it? Proceed, Counsel.
I'm so sorry, Your Excellency. Yes, we say that it is there is prohibitions under the customary international law to avoid locating military center in the capital city. But if we see the commentaries behind these articles, it stipulated that it is prohibited if a state put it in the middle of the armed conflict itself. However, we put the octagon before the armed conflict consists, right? So we stated there is no such a prohibitions that we are breached under the customary international law. Your Excellency, Madam President, I saw my time is almost elapsed, but if you would give me more minutes to finalize my submissions, I would be more than happy for this.
All right, okay, I think we can give you another 5 more minutes to finish your submission. Maybe you can proceed with your next submission, although I have more question about this point, but I think we can proceed.
Your Excellency, thank you so much for your permissions. Furthermore, these nuclear missiles can cause horrible effect, massive destructions, and huge losses to the civilians. Thus, the launch of hypersonic nuclear missiles leads to the unnecessary suffering. However, this is something contrary within the international humanitarian law, which stated that the use of means and method or warfare, which are of a nature to cause superfluous injury or unnecessary suffering, is prohibited. Moving to the last reasoning on why it is not in line with the international humanitarian law, because the hypersonic missiles is a weapon, massive destructions, which contradict with the principle of distinctions. As cited before, naturally, this weapon cannot be redirected to the military objective, and it is of course, cannot fulfill the principle of distinctions. Moving to the last sub-argumentations and supporting our main argument, we submit that Roxana violates the human rights law. First reason, because the launch of hypersonic missiles by Roxana violated the highest attainability standard of living under the International Covenant of Economic, Social, and Cultural right. We submit, Your Excellency, that use of nuclear weapons would inflict such damage to the natural environment as to violate the right of people to live in healthful and ecological balanced environment. In the present case, the launch of Roxana's nuclear missiles contradict with the idea of the right and highest attainable of living and rights to enjoy and utilize natural resources. Lastly, the attack could address the environment suffer is prohibited under the International Humanitarian Law Rule 45. Second reason, addressing the octagon by hypersonic missile proves the adequate infringement to the right of life. Under the ICCPR, it's clearly declared that each human being has the inherent right to live. Considering the massive damage and undistinguished attack occur as the results of hypersonic missile launch, it indeed raises the infringement of right to live. In addition, targeting octagon, which locations in the heart of the city, place of millions of civilians to live, would have a more severe effect on the regions. And for that reason, it proved that addressing octagon is lawful. Addressing octagon is lawful under the international law. Moving to the second main argumentations, we submitted Roxana entitled by reparation measure for the injury occurred. There are three sub-argumentations here. The first one, Roxana's attack is constituted as international wrongful act. In classifying the international wrongful act, there are two elements. First, it is attributable under the state, and second, there is breach of international obligations under the RCO Article 2. First, it is attributable under the state because attributions could be referred to as a subject in common legal practices terminology. In addition, attributions must be under a state which constitute as an organized entity and a person's who authority to act under the international law. Thus, Roxana's actions is attributable under the state. Second element, that there is a breach of international obligations conducted by Roxana. Referring to the previous argument, we already proved that the Roxana's attack by using hypersonic missiles is not in accordance with the fundamental state obligations, such as the proposals of United Nations under the Charter to maintain.
So you have already addressed this point, isn't it, about whether there is a fulfillment of the draft article on state responsibility under Article 2, isn't it? So what is the reparation that you are seeking from the court?
Your Excellency, there are two points of reparations that we ask. Those are restitutions and compensations.
Restitution and compensation. Can you elaborate more on restitution?
Okay, compensations. I mean restitution. Sorry,
yeah.
Is a measures for restoring the object closely with the previous damage in this case. We submit that the attack of Roxana affects very damaged losses such as building destructions, transportation, accessibility, and etc. Thus, Roxana must pay to rebuild and restore for the damage occurred by their attack.
So you're seeking for compensation from Roxana, isn't it, to help you to rebuild back your country? So that is a form of damages, not restitution. Restitution is to restore everything back to the original position. But the subject matter of the dispute has already gone. So how can we give you an award for restitution?
Your Excellency, term of pay. In this case, I'm not only referring to the money or whatsoever, but it can be an actions that country can do to restore the buildings or respondent party.
All right. Okay. So you have 1 minute left. Can you summarize your argument?
Thank you, Excellency. As I said before, that we are also asking for compensations because under the RCWA, compensations paid by responsible state for the material damage. In this case, Roxana must pay the compensations. To conclude our submissions, we submit that Roxana violated international law by targeting Octagon with missiles and must pay reparations to Republic of Azura for the damage suffered. Madam President, Your Excellency, may it please the court.
All right. Okay. So are there any questions from my learned colleague?
None from me.
All right. How about you, Professor Hassan?
We proceed.
Yes. Yeah, we can proceed with the next submission from the council acting for the respondent, the state of Rosanna.
Excuse me, Your Excellency, am I audible?
Yes, you are.
Thank you so much. Good afternoon, Madam President, Your Excellency, may it please the court. My name is Afiq Ahmad Hanif, and I have the honor to appear on behalf of the Republic of Roxana, the respondent in today's proceeding. I will speak for 16 minutes, and my co-agent, Ms. Johanna, will speak for 16 minutes. And with your permission, we reserve 3 minutes for sure rebuttal. Your Excellency, over the course of the next 16 minutes, I will be submitting that Republic of Azura violated international law by launching military attacks against United Provinces of Roxana and must pay reparations for the damage suffered. And my co-agent will be submitting regarding our second submission that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and need not pay reparations to the Republic of Azura for the damage suffered. If this court doesn't have a preliminary inquiry, may I proceed to my first submission?
Yeah. Are there any inquiries from Professor Hassan, Mr. Manley Stewart? No. Okay.
None from me.
Yes. You can proceed with your submission. Yeah.
Your Excellency, entering our first submission, we submit two major arguments. Firstly, Azura military attack violates international law by launching an attack towards Roxana. And secondly, Azura is obligated to compensate Roxana for the impacts. The military attack conducted by Republic of Azura occurred in Roxana territory on 15 October 2022 constituted a breach of international law and principle of international law. Your Excellency, in our first major argument, we submit three issues. First, Azura committed an act of aggression. Secondly, in any event, international law does not recognize preemptive self-defense. And lastly, the possession of nuclear weapons is not prohibited under international law. Moving to our first issue, we submit that Azura committed an act of aggression. The attack conducted by Azura is an act of aggression, whereas under customary international law, the threshold for this action has stated explicitly. To fulfill the requirement of an act of aggression, Azura has breached the principle of non-use of force and violates the sovereignty of another territory. Moving to our sub-argument that Azura has breached the principle of non-use of force. The attack launched by Azura on Roxana's territory is a clear violation of Article 2, Paragraph 4 of the Charter regarding the prohibition of the use of force against another state territory. Moreover, the prohibition of non-use of force is also recognized as a preemptory norm and customary international law. The Republic of Azura launched a conventional attack against United Provinces of Roxana, utilizing its land,
Agent.
Yes, Your Excellency.
Does Article 2 provide for any exceptions, such as an exception for self-defense?
Your Excellency, can you please repeat your question?
Sure. Does Article 2 provide any exceptions to the prohibition against use of force, such as an exception for self-defense?
Your Excellency, it is right that the Article 2 of Charter also precluded if the reason for this attack is self-defense. But if I may, I will later explain to you in our next argument regarding why it cannot be recognized as preemptive self-defense. If I may proceed, Your Excellency.
Proceed.
Yeah, proceed.
Thank you, Your Excellency. Here we concluded that the attack was a breach of Roxana's territorial integrity and the principle of non-use of force. The second threshold, that Azura's military attack violates the sovereignty of Roxana. The concept of sovereignty comprises the possession of supreme authority of a state, including the power of regulating its international affairs without foreign dictation. The decision of ICJ on the Corfu Channel case emphasizes that it is fundamental for states to respect territorial sovereignty in the matter of international relations. The statement by the United Provinces of Roxana's Ministry of Foreign Affairs that the attack was a blatant violation of international law and their sovereignty. Based on Article 2, Paragraph 4 of the Charter, it is clear that the breach of a state's territorial integrity is a violation of sovereignty. Moving to the second issue, here we address that in any event, international law does not recognize preemptive self-defense. Under international law, preemptive self-defense is not recognized since Article 51 of the Charter only recognized individual or collective self-defense. But in the present case, Republic of Azura launched the attack under the doctrine of preemptive self-defense, which has never been explicitly regulated in the Charter. Furthermore, the Republic of Azura didn't fulfill
Counsel.
the requirement of those.
Counsel,
Yes, Your Excellency.
I think the council acting for the applicant, for the applicant just now mentioned that Article 51 also include inherent right of self-defense, which is self-defense under customary international law, isn't it?
Yes, Your Excellency, but here in the Article 51 of the Charter, it is stated that only if an armed attack occurs before that they can exercise their rights to self-defense. In the present case, there is an absence of
Article 51. They're not invoking Article 51. They're invoking the right of self-defense under customary international law, which can include anticipated right of self-defense, isn't it?
Yes, Your Excellency. But then again, if I may, the first speaker of the applicant state also stated that under the Article 21 of RCWA, the state's international wrongful act is precluded if there is a lawful measure taken in conformity with the Charter. Whereas in our stance, here we invoke in Article 51 that they did not fulfill the requirement of self-defense, which there is an absence of armed attack prior, Your Excellency.
All right, okay. So how about the argument that they are relying on anticipated right of self-defense in it, or preemptive self-defense, in which they said that all the requirements have been satisfied, isn't it? How do you respond to that?
I'm sorry, Your Excellency, I cannot hear you very clearly on your last sentence.
All right, okay. So I think this is the question that was asked by my learned colleague as well, Mr. Seward. It is about whether the requirement under customary international law, preemptive right of self-defense, or anticipated right of self-defense, whether the requirement have been satisfied or not, in order to say that the attack is justifiable.
No, Your Excellency, because we would like to move on to our sub-argument regarding this matter, if we may proceed, Your Excellency.
Yes, right. Can you deal with the first requirement,
Yes.
which is that there is an imminent attack? The fact that you are, you are preparing yourself to equip yourself with a nuclear weapon, then that would be an immediate threat to your neighboring countries.
Your Excellency, regarding that matter, it is also stipulated in the facts that this development of nuclear weapon is purely to assert our sovereignty in the region. Possessing of nuclear weapons cannot be constituted an inference of willingness to use them, Your Excellency.
Okay, what's your authority for that?
Yes, Your Excellency.
What's your authority for saying that there is no prohibition against possessing nuclear weapon under international law?
Your Excellency, it is also here, if we refer to the advisory opinion of the legality of the threat or use of nuclear weapons, there is no lawful or unlawful measure regarding the possession of nuclear weapons, Your Excellency.
All right, proceed.
Thank you, Your Excellency. Here in our sub argument, here we stated that the military attack is not proportionate and the attack is not necessary. The first sub-argument, we stated that the military attack is not proportionate because the attack launched by Republic Azura is not proportionate since there was a loss of civilian life and the well-being of United Provinces of Roxana citizens. It is stated that in Article 51 of Geneva Convention, Additional Protocol 1, that civilians must be kept away from the danger of military operations.
Sorry,
Thus, the attack violated.
are
Yes,
we
Your Excellency.
still examining your submission under the prohibition against use of force, or are we moving on to the IHL?
No, Your Excellency, it is the sub-argument of our reason why the preemptive self-defense conducted by Republic of Azura cannot be justified.
All right, okay, proceed. Can you repeat your argument
Thank you,
again?
Your Excellency. Okay, here in our first sub-argument, the military attack is not proportionate. The attack launched by Republic of Azura is not proportionate since there was a loss of civilian life and the well-being of United Provinces of Roxana's citizens. It is stated in Article 51, Geneva Convention, Additional Protocol 1, that civilians must be kept away from the danger of military operations. Thus, the attack violated international law and didn't fulfill the proportionate requirement. And
Yes,
the second
but
sub-argument
for IHL, isn't it? International Humanitarian Law. But now we are looking at whether the requirements for preemptive strike under customary international law, they has been satisfied or not. So are you saying that
Excuse me.
proportionality test under IHL and also proportionality test under the prohibition against use of force, they are the same? The benchmark for the proportionality is the same under both laws.
Yes, Your Excellency, there are similarity between the two laws, which is there should be not a loss of civilians' life, Your Excellency.
All right, okay. So in order to determine whether there is a proportionality or not, then we look at the number of life lost during the attack. So what is your authority for saying that?
Your Excellency, it is clear that the attack launched by Azura caused a loss of civilian life in our territory. And of course, we are aware that the fact that Republic of Azura taken a precaution measure to minimize the civilian loss of life, but it is still, we don't see why it is to gain a definite military advantage.
How many people died during the attack?
Your Excellency, it is only stated in the Annex D from the Statement of Ministry Foreign Affairs of Roxana that is caused a loss of civilian lives.
We don't know the exact amount of civilian death.
Yes, Your Excellency.
So because you said just now loss of life, it is one of the factors why we say that it is not proportionate, isn't it? How many deaths in order to sort of like say that it is not proportionate in comparison to the attack launched?
Your Excellency, regarding this matter, we cannot see why the loss of civilian life can give a definite military advantage to the Azura's attack, Your Excellency. Therefore, we considered that it is not proportionate.
Yeah, but they can be considered as collateral damage, isn't it?
Yes, it can be, Your Excellency.
Okay, proceed.
Thank you, Your Excellency. Our second sub-argument, we stated that the military attack is not necessary, since there is no armed attack prior. In the Nicaragua case, the requirement of necessary is well established that only if an armed attack occurs is it necessary to respond to it. Hence, the military attack launched by the Republic of Azura is unnecessary.
Agent,
Yes, Your Excellency.
I have a couple questions. The first one is on the point you just made, which is that Azura must wait for Roxana to attack before it can act in self-defense. And I guess I question that, whether that's an accurate statement or not. And I'll give you a hypothetical. Let's say that Roxana put 100 nuclear weapons on the border with Azura and announced that they were going to shoot those weapons into Azura. Hypothetical, okay? I know that's not really what happened. Let's say that they did that though. Are you saying that Azura has to wait for all those 100 missiles to come over before they can act and act in self-defense by preemptively striking Roxana? I mean, is that what international law requires? That's the first question. Can you answer that one?
Yes, thank you so much. Actually, No, Azura didn't have to wait to attack Roxana if the situation are similar like what you just said, Your Excellency. But in the present case, we don't see why the possession of our nuclear weapon is a threat to their national security, since we already assert that it is to protect our interest in the region,
Okay,
in the international stage.
thank you for your response. But I just want to make sure then that you acknowledge or you concede that Azura doesn't actually have to wait. They just have to have the right conditions. The second question I have is that you mentioned that just because Roxana has developed a nuclear weapon, that doesn't mean that they will use it. I think you said something like that. This was quite a bit earlier. Okay, maybe you forgot. But I think you said something like that. But I guess my question to you is, what is the purpose of having nuclear weapons unless you give some indication, right? Some hint that there is a possibility you might use it. I mean, if you tell everyone we're building these, but there's no way we're going to use it, they have no effect then, right? No effectiveness. They can't even work as a deterrent unless there's some sort of subtle threat that they might use it. So I don't understand and that seems like a contradiction to me, that they're building nuclear weapons, but there's no possibility that they'll use it. Can you address that?
Your Excellency, thank you so much for your concern regarding this matter, but it is also stipulated in the fact that only the reason why we developed this hypersonic nuclear weapon is to assert our sovereignty in the region. I see my time almost elapsed. Can I have additional minutes to
Yes.
conclude my argument, Your
Yes,
Excellency?
you have 5 minutes to finish answering the question and also to summarize your arguments. Proceed.
Thank you so much, Your Excellency. See, here we only would like to assert our sovereignty in the region, since we also the lead country with military advance with advanced military uh, program. And as you also mentioned before, Your Excellency, there is a lot of countries in this world that developing their own nuclear weapon without actually using it, Your Excellency. Moving to our third issue in our first major argument, in our first submission, the possession of nuclear weapon is not prohibited under international law. The hypersonic nuclear missile under the possession of United Provinces of Roxana is not a violation of international law, since the Lotus Principle allows for states to exercise their jurisdiction and their sovereignty if there is no explicit international legal framework that prohibits to do so. The legality of nuclear weapon is also stated in the advisory opinion of legality of the threat or use of nuclear weapons, where there is no universal prohibition of the threat or use of nuclear weapons as such. Thus, absent such prohibitory rule, states have the right to use nuclear weapons. Moving to our second major argument, that Azura is obligated to compensate Roxana for the impacts. It was described that the military attack carried out by Azura, resulting in widespread devastation and loss of life throughout the United Provinces of Roxana, is a breach of international law. Regarding this problem, the obligation of reparation is formulated in Article 31 of RCWA as the immediate corollary of a state's responsibility. The obligation to make full reparation is the general obligation of the responsible state consequent upon the commission of an internationally wrongful act. Under this reason, Roxana respectfully asks the court to declare that Azura is entitled to obtain compensation for all the damages caused by Azura. To summarize our submission, here we submit that Azura's military attack against Roxana has breached the international law, which resulted in infrastructure destructions and loss of life. Azura's claim for a self-defense is unlawful since there is no armed attack occurred before. Therefore, Azura must to pay the reparation for the damages. If your excellencies have a future question, this concluded my argument. May it please the court.
All right, thank you very much, Council. So if there are no questions from my learned colleague, I would like to, we can move on to the next submission from the second council for the respondent.
No questions from me.
The second council for the respondent, you can proceed with your submission.
Excuse me, am I audible?
Yes, you are audible.
Good afternoon, Madam President, Your Excellencies, may it please the court. My name is Johanna, and I am the co-agent appearing on behalf of United Provinces of Roxana. As introduced by the first agent, I will be dealing with the second submissions in the next 17 minutes. I have the honor to address respondents' final submissions concerning United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not need to pay reparation to the Republic of Azura for the damage suffered. If this court has no preliminary inquiry, we would like to continue to respondent submission.
Yes, I don't have any inquiries. You can proceed with your submission.
Thank you, Your Excellency. On 29 October 2022, Roxana launched a military attack against Azura's military command and control center. Roxana exercised the right of self-defense under Article 51 of UN Charter, which gives an inherent right of states in response when an armed attack occurs. In light of this matter, there are three questions that need to be exercised by this court. Firstly, Roxana's attack in accordance with international law. Secondly, the attacks are in accordance with IHL. And lastly, in any event, Roxana did not have any obligation to pay the reparation. Your Excellencies, moving to our first major argument, here we submit that Roxana's attack in accordance with international law because first, the attack in Octagon constitutes as a self-defense. In Nicaragua, to consider attack as a self-defense, it must fulfill that there is an armed attack occur, necessity, proportionality. In any event, the attack must be directed against legitimate military targets. Turning to our first threshold, here we submit that there is an armed attack occur. Article 51 of the UN Charter requires if there is an armed attack occur. In the Congo, the court did not justify Uganda's self-defense due to there is no armed attack occurs. The court also refers to the Article 31 of Vienna Convention on the Law of Treaties that treaty must be interpreted with the ordinary meaning. Similarly, since the Charter explicitly stated that there must be an armed attack occur, Roxana's attack against Azura is justifiable due to in response of Azura's military attack in Roxana's territory. Thus, Roxana's attack was held in response to Azura's attack. Secondly, the attack has fulfilled the necessity.
Counsel or agent, on that point, to me, after learning about what happened in this case, it seemed to me that this shooting of the missile could have been more about retaliation than defense. In other words, it seemed like maybe Azura's attacks were nearing their completion or maybe done already. And after that, Roxana decides to go and blow up, so much of the Octagon and the surrounding areas as a means of kind of getting back at Azura instead of defending themselves from Azura. Sorry about that, the baby background. Can you please address that concern, Paul?
Your Excellencies, we do aware about your concern, but here our attack is necessary to respond the applicant attack because the applicant state has bring the respondent state into a collapse and destroy and damage our military. That is why this is necessary to attack the applicant state.
Well, let me give you a hypothetical then, okay? Let's just take a non-international law hypothetical. Someone comes to my house and beats me up, and then goes home. Can I go to that person's house and attack them back, or should I call the police? I mean, isn't that a similar situation where rather than attacking, there needed to be some resolution otherwise?
Your Excellencies, it is necessary to attack the applicant state because it is to protect our sovereignty and our territory. Your Excellency.
We have concern about the time frame involved here because the attack happened for quite some time, isn't it? But why towards the end of the attack, then you only, decide to attack back.
Your Excellencies, that was our last resort after the applicant state taking our sovereignty, Your Excellency.
But if you are responding on the basis of self-defense, then it must be immediate, isn't it? Because if you take too much time, if there is a delay, then we consider that as a retaliation.
Yes, Your Excellencies, because that was our last resort and we have no other way
to respond to the attack.
Yes, Your Excellency.
Yeah, you can proceed with your submission.
Thank you, Your Excellency. Secondly, the attack has fulfilled the necessity. In Nicaragua, to determine the element of necessity, the court refers to the military attack that is needed to respond to the attack. In the present case, Azura has attacking Roxana twice, and through that, Roxana need to respond to the attack, since it threatens Roxana's sovereignty. Thus, Roxana has fulfilled the necessity. Thirdly, targeting the octagon has fulfilled the proportionality. In considering the principle of proportionality, the court in Nicaragua, military and paramilitary, adopted criteria nature of the target of the use of force in the term of self-defense, which refers to a legitimate target, and it must be shown that it had a military purpose. Here, Roxana's act of self-defense was proportionate because it is only directed towards octagon. Hence, the attack in octagon has fulfilled the proportionality principle.
But
And additional,
Counsel, the octagon is located in the capital city, isn't it? Therefore, the
yes, Your Excellency.
respondent already know that if they launch a nuclear weapon, then a lot of people will die.
We do aware about your concern, Your Excellencies, but before we attack, our attack is already known by the applicant state, and then the damage and the loss of civilian from our attack is causing by the act of omission from the applicant state that did not keep away the civilian far away from the military operation.
Okay, so we say that perhaps on the part of the applicant, they have committed some wrongful conduct, isn't it? They should have relocate the octagon to somewhere else, far away from the capital city. But now you already have the information, right? That the octagon is located in the capital city, so you already anticipate the fact that a lot of people will die, but you still proceed with the attack. Right. So when you said just now that there are precautionary measures have been taken, that is not sufficient, isn't it? By giving warning only. Proceed, Counsel.
Your Excellencies, locating a military objective near of a civilian is a violation of the Article 50A, Additional Protocol 1, Your Excellency.
Right, okay. Proceed.
Thank you, Your Excellency. Additionally, octagon, considered as a legitimate military objectives, in Article 52, Paragraph 2, military targets are the object by its nature, purpose, and use that make an effective contribution to military attack and over definite military action. In the present case, octagon by its purpose used as a military command and give effective contribution to Azura's military action. Therefore, octagon was considered as a legitimate military target. Moving forward to our second major argument, here we submit that Roxana's attacks are in accordance with IHL. In the armed conflict, the parties must act in accordance with the international humanitarian law. Here, since Azura has attacked Roxana's territory, thus the IHL is applied. In response to Azura's military attack, Roxana has acted in accordance with IHL, since the attack has fulfilled the principles and in any event, the launch of nuclear missile is lawful. Turning to our first sub-argument, here we submit that The attack are in
Counsel, I have one query. How do you justify using nuclear hypersonic missile in accordance with ISL?
Your Excellencies, in IHL, there is no prohibition of the use of any weapon besides that the weapons cannot be directed against a specific military objective. It is stated in Additional Protocol 1, Article 35, Your Excellency.
Are you saying that under ISL as well, although it does not mention specifically of nuclear weapon, we can use it after knowing the repercussion of using nuclear weapon?
Indeed,
After
Your
reading
Excellency.
ISL as a whole, with 4 Geneva Convention plus additional protocol, you think it's justifiable?
Indeed, Your Excellency.
Okay, proceed.
Turning to our first sub-argument, here we submit that the attacks are in accordance with the principle under IHL. There are two basic principles under IHL that must be fulfilled in attacking the target, which are the target constitutes as a military objective and apply the principle of distinction. Turning to our first threshold, here we submit that octagon is a military objective. Any civilian object used for a military objective loses its civilian character and qualifies as a military objective. Article 52, paragraph 2 of Additional Protocol 1 provide that attack shall be limited strictly to military objectives. The objects targeted should be directly used by the enemy forces and its destruction will give definite military advantage. Here, Octagon was used by Azura for their military efforts, such as overseeing and directing the entire armed forces. Therefore, Octagon is a military objective. Secondly, the launching of nuclear missile was applied the principle of distinction. To determine that the attack is consistent with the principle of distinction, in nuclear weapon adversary opinion, the court refers that the object of attack must not directed against civilian. In Nicaragua, United States of America conducted a military attack through military troops and directly attacking the civilian by shooting. Here, Roxana's attack did not directed against civilian and only directed against Octagon. Thus, the launching of nuclear missile was applied the principle of distinction. Moving to our second sub-argument, here we submit that
I do have problem with this argument because the octagon is located in this capital city and there are 8 million people staying in the capital city, isn't it? Then how do we say that the respondent comply with the principle of distinction?
Your Excellencies, we do aware about your concern, but here we only targeting the octagon, which is the military objective, not the civilian, Your Excellency.
But thousands of people died because of the attack, isn't it? So are you saying that their death is justifiable? They can be considered as collateral damage?
Yes, Your Excellencies. It is justified as a collateral damage, Your Excellency.
Proceed.
Thank you, Your Excellency.
Sorry, I'd like to just follow up on that line of questioning for a second. When Roxana determined or decided to fire the missile, are you arguing that the missile's radius is only covers the octagon building itself, or did Roxana know very well that the radius would be much larger than the octagon itself and knock down many civilian buildings around that area? Which of those two is the correct position or your position in this case? Sorry, did you hear me okay? Did you hear my question?
Your Excellency.
Sorry, did you hear my question?
Can you repeat your question, please?
Sure. Yes, of course I can. My question is, I'm just trying to understand, okay, what happened in this case. When the missile was shot towards the octagon, did Roxana, did the government, the military of Roxana, do they believe that the radius of the explosion of the missile will only cover the area of the octagon building itself? Or did they know that it would go much wider than that and knock down many civilian buildings around the area? What is the accurate understanding? What is your understanding of the facts related to that?
Your Excellencies, the applicant state already known about the impact of our hypersonic nuclear missile by their intelligence, but they didn't take anything to take away or keep away their civilian from the military operations, Your Excellency.
Sir, if I may interrupt, of course, we are not talking about the applicant now. Your understanding before you launch that particular missile, you're supposed to know, right, the consequences of that. And is your weapon, in what sense you can see that you have not tested and you don't know the consequences. So you have got, it is within your calculation, right? This kind of possibility will happen. So how do you justify that? After that, you may move on.
Yes, we aware of Excellencies.
Okay.
Your Excellency, I saw my time almost elapsed. Can I have a minute to conclude my argument?
Yes, you have 5 minutes to summarize your the rest of your argument. Proceed.
Thank you, Your Excellency. In any event, the launch of nuclear missile is lawful because there is no prohibition of launching nuclear missile. In nuclear weapon advisory opinion, the court stated that there is no prohibition of using the nuclear missile. However, the attack must still fulfill the proportionality and attacks, and in any event, the casualty is justified as a collateral damage. Turning to our first threshold, here we submit that the attack has fulfilled the element of proportionality in attacks. Proportionality of an attack requires the balance between the destructive effect and undesirable damage. Um, Under HL, states are prohibited to launch an attack if the damage anticipated to the civilian would be excessive compared to the military advantage pursued. Here, Roxana has announced the launch of the nuclear missile. This is proof when Azura activated the missile defense, concluding that the damage of the attack will be proportional. Therefore, the attacks were proportional. Turning to our second threshold, here we submit that the civilian casualty is justified as a collateral damage. In international law, if the attacks occur by the knowledge that such attack will cause incidental loss of life or injury is forbidden, but launch an attack that had no intention of causing harm to the citizens may be permissible. To prevent disproportionate attacks, it must be determined that there were unintentional attacks causing injury to civilians. Here, Roxana's attack only intentionally directed towards the octagon and did not direct it against the civilian population. Thus, the civilian casualty is justified as a collateral damage. Moving to our last major argument, we submit that in any event, Roxana is not obligated to pay any compensation to Azura because Roxana's attack was not international wrongful act. A state is under the obligation to make compensation for the injury caused by an internationally wrongful act. Here, Roxana's attack was not intentionally wrongful act. Therefore, Roxana is not obligated to pay compensation. Secondly, in any event, if this court finds that there is a wrongfulness, here we submit that Roxana did not have any obligation to pay the reparation since under Article 21 of the RCWA, the wrongfulness of an act state is precluded if the act constitutes as a lawful measure of self-defense under the Charter. To conclude our submissions, here we submit that United Provinces of Roxana acted in accordance with international law in targeting the Octagon with its hypersonic nuclear missiles and did not have any obligation to pay reparation to the Republic of Azura for the damage suffered. Thank you, Your Excellencies. May it please the court.
So if there are no more questions from my learned colleague, maybe you can move on to the rebuttal. Can we have counsel for the applicant to present their rebuttal?
Yes, Your Excellency. Am I audible?
Yes.
Okay. Madam President, Your Excellency, my name is Nazala Firdaus, and I will be dealing for giving a rebuttal for the next 3 minutes. Your Excellency, as the Council of Azura, I would like to present the following rebuttal. First, the respondent's failure to report the self-defense actions to the Security Council as required by Article 51 of the United Charter is a significant violation. The ICJ ruling in the Nicaragua case emphasized the importance of victim states reporting their self-defense actions to the Security Council to legitimize the use of force. The attack cannot be justified under the Charter due to a clear violations of the principle of proportionality. The nuclear advisor opinion by this court clearly states that the threat of use of nuclear weapons is unlawful, contrary to the Article 2, Paragraph 4 and Article 51 of the Charter. Customary international law requires that self-defense be exercised in accordance with the principle of necessity and proportionality. It is evident that the respondent counter-attack was not proportional to the prior attack intended by Azura. Regarding to the loss of life, while the respondent argues that the attack targeted military objective, the lack of specific information regarding the causality raises concerns. We submit that without detailed reports on the status of those affected, it is premature to determine whether the loss of life pertains solely to combatants if civilians' life have been affected. So it is constituted as a collateral damage and violates international humanitarian law. Moreover, the respondents' argumentations that self-defense must conform to Article 21st of UNSZA rather than Article 51 of United Charter. It is lack of merit. Although the International Humanitarian Committee did not explicitly refer to the Article 51 during the drafting of UNSZA. So it is well established that self-defense must adhere to the provisions of the UN Charter. We contend that our actions align with the principle outlined both Article 21st of UNSZA and Article 51 of the United Charter. So we respectfully urge to this court to consider the overreaching proposals of United Charter, which mandate that said party should uphold the international peace and security while taking effective measures to prevent and remove threat and peace. Our argument maintains that our actions are consistent with the concept of conformity with the Charter of the United Nations as stated in Article 21 of UNSZA. Moreover, their argumentations didn't attack our argumentations in regards to affected environment. We say that it is breach of international obligations, specifically in the point of highest attainability of living and infringement right to live. And moreover, it is irreversible damage occurred to our civilians. So there is no argumentations attack on this point. But lastly, and to conclude our rebuttal, it is unjustified to say it's last resort to the respondents because they failed to maximize the previous diplomacy effort. They try to do this shadow and try to labeling our discourse in social media. So there is no clear good faith in resolving the dispute on the diplomacy discourses. That's all our rebuttal. Madam President, Your Excellency, may it please the court.
All right, thank you. So if there are no more questions from my learned colleague, then we can move on to the rebuttal from the respondent.
Thank you so much, Your Excellency. My name is Afik Ahmad Hanif, representing the respondent state in today's short rebuttal. Here, we would like to address the argument of the applicant state that there is an absence of UNSC report, whereas the applicant state also didn't report to the UNSC regarding their self-defense taken before they attack us, and also the UNSC report is not cumulative if the necessity and proportionality has been fulfilled under this court. And then secondly, we did fulfill the requirement of proportionality and necessity. In the first element, we should take into consider that the attack launched by Republic of Azura put our nation in the brink of collapse, and most of our military armed forces are in disarray. Therefore, our only last option as our last resort is to use the hypersonic nuclear missile, whereas our attack is already taken a precaution, whereas we already take a precaution measure where we had in mind to attack the octagon. There is no intention to put all the civilians in danger. And then our action is also in conformity of the charter and in RCWA, as the applicant state mentioned before, that we did not fulfill the requirement of self-defense. We did, in fact, Your Excellency, as we previously explained in our pleading session, that it is proportionate and it is necessity for us to exercise our our right to self-defense regarding the attack that was launched by Republic of Azura. And then and lastly, our weapon is not an infringement of their sovereignty. We don't see why and what is the capability of the applicant state to dictate our internal affairs in our jurisdiction regarding the possession of nuclear weapon, Your Excellency. That should conclude all of our short rebuttal. Thank you so much, Your Excellency. May it please the court.
Right, okay, so if there are no questions from the members of the court, then I think that would end our proceeding today.
No questions from me.
Right. So I'll hand over the session to the organizer.
Hello,
Yeah.
am I audible?
Yes.
Okay. So, Your Excellencies, that concludes the round. We will now adjourn to the deliberation room for further proceedings.
Thank you, Your
Participants will be
Excellency.
moved
Thank you,
to
applicants.
the
Thank you so much, Your Excellencies.
breakout rooms.
Right. So I think we have to discuss about the marks.
Yes.
Yeah.
Your Excellencies, please note that we have up to 15 to 20 minutes for you to complete your score sheets.
Score sheets. Yeah.
Kindly
Then we
score the
got-
participants based on the
Yeah.
performance, based on the provided criteria.
Mhm.
Once completed, please email the score sheet back to the organizer at competition.ilsauniza.my.
I see. Right.
Please take your time.
May I know the name of, just to clarify the name of the first applicant, Muhammad Iksan or
For the first applicant, Muhammad Ahsan.
Ahsan?
Yes.
Yeah.
Muhammad Ahsan. Alright, Muhammad Ahsan.
Yeah.
Ahsan. And then Afiq, and then
Sorry. How is that spelled? Aksan?
Ahsan.
Hassan?
Ahsan.
A-H?
S-A-N.
S-A-N.
Yes.
Thank you.
All right. Okay.
Yeah, lucky we chose you, Prof. Umi, as the president. Wow.
I've not done
You're
this
so
for a long
great.
time. I've not done
My
this
word,
for a
my
long time.
goodness, the poor students. They didn't think they would have someone like you, I think, with so much knowledge. That's really impressive.
All right. Thank you. Okay, so maybe we can decide who is the winner. Whether we should decide in favor of the applicant or the respondent. So
Sorry, I need to add up my scores. I put
Yes.
marks in, but I haven't added them yet.
Yeah.
Could I have a couple minutes?
Yes, yeah, sure. Right.
Yeah, me too.
Mm. Just a- Mm. 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 So, mm. Mhm. Mm. 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 Mm.
Is Angelica? Is that right? Is that how I address you?
Yes.
Yes. So how do you determine who the winner is? Do you add up everybody's marks, or do you look at
Mm.
maybe if two of us chose one team and the other chose the other team, then that's how you determine the winner? How do you determine it?
Based on raw scores.
Raw score. You just add everything up.
Yes, that's true.
So
So-
do you want us? No, please. I'll let you go ahead.
So we don't have to choose the winner now. So do we reveal our selection, or it depends on the score sheet later on?
It depends on the score sheet.
Even the score sheet.
Yes.
So personally, I think I would decide in favor of the applicant. Yeah. I think the counsel for the second respondent, she was quite weak in several aspects. So for that reason, I decide in favor of the applicant. So I'm not exactly sure about about you. Yes, but that would be my selection, I guess.
Yeah, I'm. If we go by the team, I would agree with you. Applicant should be the winner,
Mm.
but by mark as well,
Mm.
based on my score,
Mhm.
applicant score more marks than the respondent. Also, mainly due to the second respondent, is a little bit need more improvement.
Yes. Yeah, in terms of answering the questions, and then
Yeah.
yeah.
Add my 2 cents in maybe then. So actually, I agree with the two of you. Actually, if I had to just name who I thought was better, I thought the applicant counsel was better. But I will tell you that I added up my marks,
Mm.
and they're actually even.
Yeah.
So, and the reason I'll tell you why actually that I was a little bit more sympathetic, maybe to the second counsel of the respondent than maybe both of you were, because actually I think that that's probably the hardest argument. The worst facts were the ones that she had to deal with. And the best
Yeah.
facts were the ones that the second respondent, the second agent for the applicant had. And that was actually my strongest. He got very high marks for me. But I also felt like, given the facts and given the nature of the arguments, and I mean, that's a tough one to argue for. I agree with you guys that she could have done much better. No question about that. But I also gave her a little bit of leeway because I felt like that was a position that was quite challenging to take on.
Yes, you're correct. Because how do we argue that the nuclear weapon, usage of nuclear weapon is legal under ITI, isn't it? I think she did try her best, but perhaps some of the questions she has not really addressed it. Perhaps maybe she can just concede and move on. Yeah, I think the question can be handled better. Yeah, but yeah, you're right. The second point is not really in favor of the respondent. Yeah, so.
But I think based on our discussion just now, it seems like things will go for the applicant side. So I think that's consistent with everyone's general feeling about things. So I think that yeah.
So the
I don't think we should worry too much.
Yes.
Do we also choose in one best orally or something like that?
We will be calculating that based on the scores.
Based on that marks, yeah? Good.
Yes.
So okay, so we'll be shooting email out.
Yeah, sorry. So Ms. Uma, I guess, do I call you Ms. Uma?
Yes, I am Uma.
You go by that? Okay. So I need a little bit of time to type in the comments. I've filled in the marks, but the comments I haven't done yet. I wrote them on a piece of paper. I'm much faster. It's easier for me to write with my hand, in handwriting. So I would take a few minutes, okay, just to type in my remarks into the sheet, and then I'll send it to you.
Yes, that's completely fine. If you need any assistance emailing the score sheets back to us, please let us know.
Yes, I think maybe we can resume with the session, and then we can give you or send you our feedback later. The score sheet.
Would it be alright if you send in the score sheet first and then we move on to the feedback session? Because we would have to calculate the marks for the closing ceremony.
Yeah. So we have to do it now.
Yes, during the deliberation. I really apologize for that.
Don't worry. I just shoot out the email. I don't know whether you received. Please, could you kindly clarify?
Just a few moments, Professor Hassan.
No worry. Just take your time.
Yes, we have received your score sheet
already.
Umasri, I think we are ready with our comment. So perhaps we can move on.
Sorry, can I just check? Have you emailed?
Oh, you want us to email to you right now?
Yeah, yes. Sorry, Dr. Umi.
I still want to check my my feedback.
Oh, okay. So, all right. Maybe you can email the score sheet back to us after the feedback session.
Yes, I think so. That would be better because yeah, I'm a bit bad with typing.
Yeah, that is all right. So, Mr. Stewart, can I just confirm, have you emailed the score sheets?
I will email to you.
Just now.
Yeah,
2 seconds ago.
Yes.
All right. Okay. Thank you so
check
much.
your
So
emails.
I will add the participants back to the main room.
Yes. Thank you.
Did you receive my marks?
Yes, I have. So I believe the participants left the meeting room. Please wait a moment. I will ask them to come back in. Team 1004, can I confirm that both councils are in this meeting room?
I'm still calling my partner to join the room. Sorry.
All right, all right. Team 1003, can I confirm if both councils are in this meeting room?
Yes, we are both in this meeting room.
All right.
So, since the members of both teams are here, I think we can proceed with our comment about your performance. Maybe I would like to invite my learned colleague first to give you some feedback. Perhaps Professor Hassan, you would start first.
No, I don't have feedback so far.
All right, okay, so Mr. Stewart, can we hear feedback from you?
Yes, sure. Sorry to ask a question from the organizers. Are only the teams allowed to hear this feedback, or are there other audience members?
Only the teams are here currently.
And when we did the final round, was there an audience or just the teams?
Yes, we had spectators.
Okay, and you don't want them to hear the feedback?
I think they left the meeting room.
Okay. I mean, just as a learning exercise, I'm just suggesting that when you're a spectator, you can also, sometimes learn from the feedback. Because I mean, at least when I watch mooting competitions, sometimes I think in my mind, oh, that's good, that's not so good. And then I hear from the actual judges and I'm like, okay, that's quite interesting. Maybe they disagree with me. But anyway, we'll just continue, sorry. So congratulations to the four of you for finishing, for making the finals, first of all. That's great. And for finishing without breaking down or crying or anything, good for you. So I mean, I'm a mooting teacher at University of Malaya, and I know how difficult it is to be a beginning mooter. And in fact, when I was a student, also I struggled a lot in mooting. So congratulations and good job to the four of you. I do have some feedback. I did read your memorials, by the way, and I listened to your oral submissions. And I guess the main point that I would like for you all to remember as you move forward in your mooting journey is for some judges like me, for example, the most persuasive arguments are when you're able to address some of your weak points better and some of the strong points of the opposite team better. So in other words, what I'm suggesting is that sometimes as a young lawyer or as a law student, we tend to focus on our own strong points because we think this is what we're supposed to be arguing, is our very strongest points. And then we kind of neglect maybe or try to brush over some of the weaknesses in our own arguments. And we try to dismiss very quickly some of the strong points of the opposite team. For a judge like me, I like the mooters who are able to spend more time on the more contentious issues, on maybe your weaker points and their stronger points. So I felt like in our session today, some of us, we asked you questions, and I feel like you could have been a little more thoughtful in your responses, a little more balanced, like kind of acknowledging a little bit better that this is a tough issue, that it's not so clear cut. So sometimes I think that sometimes new mooters tend to try to frame every issue as if it were very clear. It's clear that the proportionality test is met in this case, or it's clear that it's not met. In fact, it's not quite so clear. It's a little more in the gray area. So what I suggest is to acknowledge at least sometimes that it's a little more unclear, perhaps. But nevertheless, even though there are some arguments of merit on both sides, even though that's true, your arguments are a bit stronger. And to show me that they're a bit stronger, that's when you turn to precedent. Okay, turn to the cases, turn to the support for your arguments that persuade me that your arguments, even though the other side has some good arguments too, that your arguments are a bit better, and especially given the facts of this case. I think that's my main point that I'd like to emphasize to you also, that you can make arguments that are what I would say are a little more nuanced, that acknowledge a little bit more the difficulties in balancing these tests, that we use when there's a war or armed conflict between countries. Only bad things happen in wars. And how do we weigh all of these bad things to determine who is the least bad party, I guess you could say. And to help us judges to kind of weigh those a little bit better is something that I would encourage all of you to do a lot more of. Let me just look at my piece of paper here. Okay, the other thing is, the second and final point that I will emphasize is that you should consider judges' questions as a really important part of what you need to spend your time on. So when judges ask questions, they're asking you usually some of the more difficult aspects of your case. And they want you to spend some time elaborating and focusing on that. And then in your rebuttals and full rebuttals, you kind of sometimes come back to these issues that the judges have raised, because those are the ones that we really want to hear about. And so I hope that as you continue again, you don't consider a judge's question as something that is like just trying to bring you down, or trying to test you, or trying to cut up your argument. Try not to think of them that way, because if you do, then you will think of us as your adversary, as sort of your enemy, and that you're trying to battle against us in some kind of an argument. I would suggest that you reconceptualize how the judge's role, and think of us as people who are looking to you for guidance. And we're looking to you for guidance on the law, for guidance on the facts, for a clear argument that is persuasive. That's what we're really looking for. We're not really trying to, battle you in some kind of a test of wits or anything. That's not our role, and it shouldn't be. And I hope that you don't perceive us that way as well, but as more of people that you're trying to guide and to persuade. Those are the 2 points I want to emphasize. Thanks very much.
Thank you very much. So a few comments from me. But firstly, are you in your first year or second year of your degree program?
Most of us in second year, but
right. Okay. So all of you are in your second year. Right. So
except for my co-counsel here.
Oh, all right. So have you done international law in your second year? Is it in your second year you were doing your international law?
Yes, it is our third.
So you're still doing your international law in your second year, isn't it? All right. Okay. So congratulations. You made it to the final, and I thought you did well during the final round. Just that from my part, I think there are certain things that you can improve, especially concerning your knowledge about the law, especially when we talk about the use of force and the ITI, isn't it? Sometimes you mix these two. So perhaps if you want to argue on the use of force, then you make it clear that this is your first argument, and then you can move on to the ITL, because when you talk about the provisions, from the Geneva Convention, and then you mentioned it when you talk about proportionality under the provision against use of force. So it tends to be a bit confusing on that basis. So perhaps I think this would be my first comment to all of you, to try to improve your familiarity in this area of law. But I do understand the fact that perhaps you have not done use of force yet. Then if you have not done it, this is a very good attempt on your part to address this area of law, and in which I think the Moot problem is quite interesting. It's very topical. It's about to what extent nuclear weapon has become, provision against usage of nuclear weapon has become customary international law. So it's a very interesting question. Apart from the area of law, your knowledge about the area of law, I do have a few comments about style and your demeanor. For Hassan, you mentioned "may I direct," isn't it? If you want to use "may I direct" for a tribunal proceeding, then I think it will be okay, because the process is not that formal. But for a court proceeding, we do not use direct, maybe invite, and especially if you are submitting in front of Malaysian lawyers, okay, they are very particular about the usage of direct. So perhaps maybe you can use invite instead. And then you mentioned something about I have already submitted this point. Okay, perhaps instead of using that phrase, you can use "I reiterate." I think that would be better. All right, because again, some judges, they tend to get a bit irritated with the usage of these phrases, right? Maybe you can put that into consideration for your next Moot participation, Moot competition. Okay, and then about your argument, because sometimes when we ask you question, right? I know the fact that you have that will be something that you will address in the latter part of your submission, isn't it? Bring it forward, all right? Bring it forward. Be flexible with your argument, all right? So you have to address the question straightforward, all right? So if possible, do not defer answering the question, all right? So you bring forward the argument, but you don't have to deal with that point anymore, all right? And then again, in terms of the structure of your argument, you mentioned about ILSA, whether the requirement have been satisfied or not for the purpose of getting the compensation, because Article 2 is basically you addressing whether there is a violation of international law. So that would be the first part of your argument. So the second part, you only focus on the kind of compensation or the kind of remedies that you would want the court to award you, right? So you don't have to repeat your argument anymore. So I guess my main concern is in terms of the structure of your argument, right? It is a general comment to everybody, right? Again, I think the second counsel for the applicant during rebuttal, I think this is something that have been mentioned by my learned colleague just now, Mr. Stewart. When you do your rebuttal, please stick to 3 main points, right? Do not go beyond that. And again, you need to use signposts. Okay, how many rebuttals do you have? Moving on to from one point to another point, right? So you have to make it clear, right? So I thought the usage of signposting, it should be, you need to use more signposting in your arguments, right? I think it also applies to the first counsel for the respondent, Afiq. I thought you need to use more signposts during your rebuttal. Again, the same feedback. You need to increase your familiarity with the area of law, and then the cases, and then at the same time, perhaps language. Present tense, past tense, so you need to work on that as well. And then the usage of sources, because for most of you, you cited secondary sources to support your argument instead of primary sources. So for the respondent, I noted that they relied more on cases, primary sources, but for the applicant, most of your arguments were based on secondary sources, NATO bombing, Security Council resolutions on South Africa. So I thought perhaps you can look at primary sources first, then you look at secondary sources, right? And then obviously, again, like you need to, if you're citing NPTs in it, obviously you need to know how many states have ratified the convention. So, so I think that's all from me. So I will write my comments on the score sheet later on for you to read, right? Thank you.
If I can just add that I have written individual comments for all 4 of you on the score sheet, so those will be provided to you from the organizer.
Yes. Thank you, Your Excellency. Thank you. Respondent.
Thank you. I think that's the end of the session. Thank you very much, everybody. I had a great time.
Thank you so much, judges.
Thanks, everybody.
Right. So yeah, Umasri,
Thank you so much.
Thank you, everyone.
Everybody. Umasri, I will send it to you right now.
All right, sure. Thank you, Doctor.
Bye.
All right. Have a great day.
Yeah.